Okay, this is Thomas Freed on the Liberty Works Radio Network. And yes, that's right. We're back with the Truth Attack. Okay, let's get right into this. We are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the broadcast network operating and the show's coming. So if you enjoy the information, the lectures, the topics, the revelations, and the guests that appear on the other shows, we sure would appreciate it if you could find your way over to the LibertyWorksRadioNetwork.com website. If you're not already there, listening through the online radio link, we sure would appreciate it if you could go on over and get signed up as a monthly subscribing member, even if it's as little as $10, $20 a month. Every membership helps, and we do need your support to keep the information coming. And if you want to be fully informed on the latest developments in the battle against the unconstitutional operations of the IRS, the DOJ, and the rebellious lower federal district and circuit courts of appeals, you need to get right over to tax-freedom.com and read the article I've got posted there that SCOTUS killed the income tax. SCOTUS killed the income tax. Here it is. It's right there over on taxfreedom.com, and you need to start reading because this case that was settled in June destroys every single federal claim for income tax that's in every single court in the country, both civil and criminal. It exposes every lien filed in every courthouse in the country as a fraudulent instrument pursuing a tax that doesn't exist under the Constitution. Doesn't exist under the Constitution. It turns out the myth, there is no law, was correct. It also turns out the myth, it's voluntary, was correct. Why? Because if you claim the source of authority is the 16th Amendment, there is no enabling enforcement clause to constitutionally authorize Congress to write law in that amendment. And therefore, it can't be the source of any authority in the courts because nothing is made enforceable. Without the enabling enforcement clause, Congress can't write law. If there's no law, it must be voluntary. So if you tell me the source of authority for the tax is the 16th Amendment, I know for a fact as a student of the Constitution, that it has to be voluntary because Congress isn't constitutionally authorized to write law by an enabling enforcement clause. And without the ability to show that authority for Congress to write law, for the new power allegedly created by the amendment, the court can't establish subject matter jurisdiction to enforce any claim based in the 16th Amendment because it's necessary to show not only a constitutional power to exercise in taxing, which you can claim the amendment provides by letting them tax income, but it is also necessary for the Constitution to constitutionally authorize Congress through an enabling enforcement clause to write law to enforce and administer to the new power. And, of course, if you start with Article 1, Section 8 as your claim to authority, well, then there is no law because the impost taxes foreign activity, foreign imports, foreign persons, and in foreign places. It doesn't tax the domestic labor of the citizens. Duty taxes exported goods and doesn't tax the labor of the citizens. Excise power taxes commodities, licenses, and corporations, but doesn't tax the labor of the American people. In fact, the labor unions had Congress write a code section, Title 15, Section 17, which says the labor of a human being is not a commodity or article of commerce. And the reason why they had them write that is in the 1930s when Social Security came down, the labor unions saw it coming. They said, oh my God, they're going to try and tax our labor. And so they hired attorneys to look into it. And the attorneys said the only way to do that is to argue labor is a commodity and can be made subject to excise taxation. So the labor unions went right over to Congress and lobbied Congress to write the law. Title 15, Section 17, the labor of a human being is not a commodity or article of commerce. So the federal government is foreclosed on arguing labor is a commodity subject to excise taxation. That means there is no power to tax labor under Article 1, Section 8. And the government has effectively admitted that by claiming the authority to tax your income is created by the 16th Amendment as a power to lay a non-apportioned direct tax on all sources of earnings, which is a constitutional fraud. How do we know it's a constitutional fraud? Because the Supreme Court just ruled in the Moore case in June that income taxes are indirect taxes. They are not direct taxes under the 16th Amendment. They are not a non-apportioned direct tax. They are not a tax authorized by the 16th Amendment. Every single one of the DOJ's and IRS's arguments for a direct non-apportioned tax under the 16th Amendment are wrong. Every single element of the argument is wrong. It's not direct. It's not under the 16th Amendment. It's not a non-apportioned direct tax. It's an indirect tax that only has to be uniform under Article 1, Section 8, Clause 1. But that's impost, duty, and excise and nothing else. And it's impossible to argue that the 16th Amendment, in making income tax part of the indirect taxing powers of Article 1, Section 8, Clause 1, actually created a fourth power to tax indirectly beyond impost, duty, and excise. The reason why that's impossible is because there's no enabling enforcement clause in the 16th Amendment to authorize Congress to write law to enforce a new power. And that's why the Supreme Court rejected the argument that new powers were created. There are no new powers created. Income is not the object of the tax. It's not the subject of taxation. It is the yardstick that measures the amount of tax owed on the earnings derived from the federally taxable activity or transaction subject to some impost, duty, or excise. Income isn't taxed. It's the impost and the duty and the excise that is the subject of the tax. Income is the yardstick. But if there's no impost, duty, or excise, you don't just tax the yardstick and tax everything the man earned. He's not an inherently taxable person, the way the corporation is an inherently taxable person, because it's taxed on the privilege of incorporation. And virtually every single penny it makes anywhere on the planet can be taxed through the excise power imposed on the privilege of incorporation. So there's a difference, a big difference between the corporate person and the individual person as a citizen, and that difference is lost when everyone is treated as a person for purposes of the code. And this is how they transformed the indirect tax into a claim that it's a direct tax without apportionment. Is they tax your labor directly based on sources of gross income without regard to whether or not any of those sources flowed to you from an impost, duty, or excise taxable activity. And without impost, duty, or excise, it becomes a direct tax on your labor, which is not authorized, was not intended, isn't constitutional, and doesn't exist in the Constitution as an authorized power. And because impost, duty, and excise don't reach your labor with legal effect as a tax, the government has been compelled to argue it's a non-apportioned direct tax under the 16th Amendment. And they have argued it everywhere. This reversal of the original Supreme Court decision in Brushaber has been ruled by the 8th Circuit, the 9th Circuit, the 11th Circuit, the 6th Circuit, the 7th Circuit, the 4th Circuit, the 5th Circuit. It's been ruled by all the circuits. Every single one of them are in rebellion against the Constitution, against the Supreme Court, against the actual holding, against enforcing the limited powers to tax that actually exist. This is a judicial rebellion of the highest order of sedition. Because what they're actually enforcing in place of constitutional taxation is, of course, the second plank of the Communist Manifesto, which reads a heavy, progressive, or graduated income tax. That's where you find graduated, non-uniform taxation of the people. That's where you find the class warfare created by writing different laws for different groups of people, like blacks and whites, or Jews and Christians, or gays and straights, or male and female, or young and old, or the wealthy or the poor. Whenever you write law that discriminates between the wealthy and the poor, the wealthy will co-opt the writing of the law. And no matter what you went in with intentions, what you will come out with as results is a law that benefits the wealthy and punishes the poor. Because the money writes the law. Not intelligence, not common sense, not good intention. And that's why the laws always end up punishing the common man and rewarding and protecting the fraudulent institutions, the government, and the system rather than your rights. So this is an outright rebellion against the Supreme Court decision. It's been held by all the circuit courts that it's frivolous to argue it's not a non-apportioned direct tax. It's frivolous to argue it's under Article 1, Section 8. It's frivolous to argue Article 1, Section 8 doesn't allow it. It's frivolous to argue the 16th Amendment doesn't allow it. And they fined people to $25,000 a shot, millions and millions of dollars for making what turns out to be the correct argument. Because here's what the Supreme Court just said in Moore. Here's what the Supreme Court just said in Moore. Congress has not enacted an apportioned tax since the Civil War. Well, that's funny. The income tax was enacted in 1913. That's since the Civil War, and every single court in the country has been telling you it's a direct, non-apportioned tax. And the Supreme Court says here, they're lying to you. They're lying to you. Congress has not enacted an apportioned tax since the Civil War. They haven't enacted an apportioned direct tax since the Civil War. By contrast, indirect taxes are the familiar federal taxes imposed on activities or transactions. I'm reading from the opinion now in Moore et Ux v. United States, settled in June. That category of taxes includes duties, imposts, and excise taxes, as well as income taxes. Indirect taxes include impost, duty, and as well as income taxes. Couldn't be any clearer. It's not a direct tax. It's an indirect tax. And he cites the Constitution at Article 1, Section 8, Clause 1, and Amendment 16. The 16th Amendment makes it indirect, not direct. The Supreme Court decision of 4 months ago directly contradicts every single circuit and district court in the country rendering decisions in tax cases. It's all fraud. Every single case in every single court has to fall because they're pursuing the enforcement of a direct non-apportioned tax that doesn't exist under the Constitution. It's indirect. It's not non-apportioned direct under the 16th Amendment. That's a fraud. That's a constitutional fraud being perpetrated on the American people by the judges, the federal judges. This is sedition of the highest order. Sedition of the highest order. They go on. Because income taxes are indirect taxes, they are permitted under Article 1, Section 8 without apportionment. Therefore, the 16th Amendment expressly confirmed what had been the understanding of the Constitution before Pollock. Taxes on income, including taxes on income from property, are indirect taxes that need not be apportioned. Citing Bruce Shaber, 240 U.S. at 1518, from 1916. They're going back 108 years, citing, reaffirming the original decision. And we'll get more of this when we come back. This is Thomas Freed on the Liberty Works Radio Network. We're going to take a 5-minute break here for some commercial messages. Okay, this is Thomas Fried on the Liberty Works Radio Network. I'm just going to get right back into this. When we broke off before the commercial break, I was talking about how what the court has done here is reaffirm Bruchaber. And as I read, the 16th Amendment confirmed what had been the understanding of the Constitution before Pollock. That direct taxes, that taxes on income, including taxes on income from property, are indirect taxes. And by citing Bruchaber, they don't give us a new decision, they reaffirm the original decision, which means there's 111 years of unbroken precedent. It precludes and forecloses on the possibility of the government ever arguing that something happened during the intervening period of time that did turn the income tax into a direct tax under the 16th Amendment, and it was only restored to the indirect tax that it is by the Trump tax law because of the constitutional authority statement, which declares the authority for the income tax to be Article 1, Section 8, Clause 1. So Congress tells you it's 181. The Supreme Court tells you it's 181. The legislative branch, the judicial branch, 181. But the executive, they're arguing the 16th Amendment, except when they get in front of the Supreme Court. Then they're unable to show the court a direct tax in the Internal Revenue Code. That's what it says in the decision. I think we need to review what they did in Pollock, because they mentioned that in the confusion. So let's look at that. In 1861, Congress enacted the nation's first unapportioned income tax. I'm reading from the opinion again, 12 Stat 309. The Civil War income tax was recognized as an indirect tax under the head of excises, duties, and imposts. Bruchaber, 240 U.S. at 15. See also Springer v. United States, 1881. So again, they're pointing out the very first income tax in the Civil War was indirect. And they said that in Bruchaber, reaffirming the decision in Springer. So it's always been indirect for 165 years. It was never a direct tax, non-apportioned direct tax under authority of the 16th Amendment. So let's go on reading from the opinion. In 1895, however, in Pollock v. Farmers Loan and Trust Company, this court held that a tax on income from property equated to a tax on the property itself, and thus was a direct tax that had to be apportioned among the states. 158 U.S. 601 at 627, 628. They're citing Pollock. The Pollock decision sparked significant confusion and controversy throughout the United States. Congress and the states responded to Pollock by approving a new constitutional amendment ratified in 1913. The 16th Amendment rejected Pollock's conflation of income from property and the property itself. The amendment provides that Congress shall have power to lay and collect taxes on income from whatever source derived without apportionment among the several states and without regard to any census or enumeration. U.S. Constitution, Amendment 16. Therefore, the 16th Amendment expressly confirmed what had been the understanding of the Constitution before Pollock. Taxes on income, including taxes on income from property, are indirect taxes that need not be apportioned. Bruchaber, 240 U.S. at 1518. So repeatedly they cite Bruchaber. They are repeatedly reaffirming Bruchaber to point out that all direct taxes must be apportioned. Indirect taxes don't have to be, and the income tax is an indirect tax under Article 1, Section 8, not a direct tax under the 16th Amendment. So what on earth happened in Pollock to create all this mess? Well, in Pollock v. Farmers Loan, as the court points out, the court ruled that the income tax on rents was a direct tax because of the source tax. Rent streams from property, taxes on property are direct taxes. As a direct tax on property, it couldn't be sustained because it wasn't apportioned to the states for payment. So they declared it unconstitutional. And that led to the 16th Amendment, which has given us the nightmare. Every time the Supreme Court makes stupid, fatal errors, it creates a nightmare for the country. Dred Scott was a stupid fatal error, and it created a civil war, a nightmare for the country. And this decision, Pollock v. United States, was a stupid error, and it created the 16th Amendment, which has been a 100-year nightmare for the American people. The reason why Pollock was stupid is because I have never in my life seen a piece of property write a check to pay the rent. The rent, the income, the earning, they don't stream from the property. They stream from a third-party tenant's leasing of the property. And property is land, and land is a commodity. And when a tenant leases land and grows crops on it, they're depleting the value of it as the nutrient value is lowered each year. Crops are successively planted without investing back into the land a green fertilizer. So when you lease land to grow crops, you're consuming the commodity, and that's excise taxation. The taxation on rent streaming to a corporation who's inherently taxable on everything could have been justified as an excise on the consumption of the commodity land. An even simpler application of the excise taxing powers could have been proclaimed that it's the privilege of incorporation that's being taxed. And all earnings earned by the privileged entity are subject to tax no matter where they source from. Because it's the corporate privilege that's being taxed, not the land, not the property, not the rent. And that's what they should have held. It's indirect as a tax on the privileged corporation, and it doesn't apply to the individual citizen because they earn rent by right to lease their property in their own state. And the Fed has no jurisdiction to interfere with that transaction. So they can't tax the citizen's rent or their interest or their dividend or their compensation or their salary or their wages unless it's derived from some activity subject to an impost, duty, or excise. And this is how they've been able to appear to justify the claim that it's a direct tax. It's based on earnings, a gross income. It's not based on impost, duty, or excise anymore. It's based on you earned, you owe. That's a direct tax on labor. It doesn't exist. It's not in the Constitution. It's never been authorized. It's a constitutional fraud to claim it's authorized by the 16th Amendment. It isn't. And it isn't authorized in Article 1. It's not a constitutional tax. The whole system is a 100-year fraud, or at least an 80-year fraud from 45 at the end of World War II, which is actually the first time federal taxing powers touched the labor of the American people. It was the victory tax in 1942, the 2-year temporary war revenue measure. That was the first time in history the labors, the right to work, the fruits of labor derived from the simple exercise of the right to work, the non-taxable right to work, was the victory tax. First time in history, tax touched wages. And nobody complained. So when the victory tax expired and the war debt had practically been paid off in 2 years instead of the 55 to 60 they were expecting, Congress decided they couldn't let the power die, so they reenacted a tax system that allows for withholding when you ask for it on a W-4. But there's no tax imposed to withhold. Chapter 24, collection of the tax by invoice, doesn't impose any tax. It lets you assume you're subject to the collection of the tax from 1913, the tariff collected from foreigners under 1441, 1442, 1443 by withholding agents. The original tax collectors, because employment wasn't part of the tax code till 1945. So employers didn't collect the income tax. It was collected by withholding agents, defined at 7701A16, who only had authority and a duty to collect from non-resident aliens and foreign corporations. There was no authority to collect the tax from citizens. There still is no authority. There's only the authority to deduct and withhold from non-resident aliens. The employer has to ask you for permission. He can't just do it because the tax is owed, because there is no tax imposed and no tax owed. They have to have your permission to force you to pay a tax before next year on April 15th when it's finally legally due. But they can't force you to pay something that isn't due before it's legally due without violating the 13th Amendment's prohibition on involuntary servitude. They can't force you to service a future obligation, especially when it's not a tax obligation. It's their debt that you're servicing. And the proof is, none of the money goes in the Treasury. If the money went in the Treasury as required by law, you wouldn't have to file to pay the tax. It should have already been paid and recorded as such. You'd only have to file to get a refund. But you have to file to pay the tax because none of the money went in the Treasury. All you got to do is check the back of the last check you sent to the IRS or the Treasury for tax on April 15th with your Form 1040. Turn it over. See you endorsed it. If it was tax, it will say deposit to the U.S. Treasury. How much you want to bet it doesn't say that? What it says is paid to NEFRB, Federal Reserve Bank, a private corporation. Why is a private corporation cashing your so-called tax check when the law requires the tax be deposited in the Treasury? The law, of course, requires that because Congress can't write appropriations against money not in the Treasury. And taxes are money for the government to spend, so in order for Treasury, the government, Congress, to be able to spend it, it has to be in the Treasury. But when it goes around the Treasury to the Federal Reserve Bank, that means that across the entire year, no tax revenues are accumulating at the Treasury. And what that means is that when there's a hurricane and Congress runs to the Treasury to draw $1 billion to give to FEMA to go help the disaster victims, oh, surprise, there's no revenues there. No tax revenues have been accumulating. It's empty. All the money's been routed to the Federal Reserve Bank. There is no money for Congress to draw on existing revenues. So what do they have to do? Yeah, that's right. Borrow another $1 trillion. Whoops, 37. Whoops, 38. Whoops, 39. Whoops, 45. Whoops, 50. We are rapidly arriving at the point, people, where every single penny of tax revenue raised will be required to be given to the Federal Reserve Bank simply to service the interest on the $50 trillion in debt. Every single penny to the Federal Reserve Bank before a single penny is available to pay for government services. Every single cent. And that's when debt service becomes slavery, tyranny, despotism, the end of freedom, the end of liberty, the end of limited government. Because it has to become omnipotent to keep itself funded at that point. And that's when it starts taking over everything in society. The oil fields, the gas fields, the mines, the utilities, the factories, the food production centers. You want to see how it goes? Go to Cuba. Go to Russia. Go to Venezuela. Go to China. Go to North Korea. See how well it works out for them. So, what does the 16th Amendment do, since there's no enabling enforcement clause in it, to authorize Congress to write any new law at all to control the behavior of the American people, which it can't do? Who does it control? It controls the federal judges, and only the federal judges. It bars them from ever using a source argument as the basis for the finding again that an income tax is direct because of the source text. They're not allowed to do that anymore. They can't say it's direct because of the source. They are the ones precluded from acting. Not the citizens. It does nothing to the citizens. There's no enabling enforcement clause. No law is authorized. The 16th Amendment controls no one but the federal judges. And they have been lying to you about it for 65 years to become the omnipotent despots that rob you. Okay, this is Thomas Fried on the Liberty Works Radio Network. This is the Truth Attack Hour, and I was just talking about how bad and horrible the decision, the Pollock decision was. Just like Dred Scott, which gave us the Civil War, this Pollock decision, resulting in the 16th Amendment, has reduced the country to what we have now, a class warfare system that's nearly coming to civil war, although civil rather than weaponized. So you have a 50-50 nation divided on exactly the lines the Constitution was allowed to be broken by the combination of the Pollock decision, the 16th Amendment, and the confusion that has resulted since then. Not between Pollock and the amendment, but since then. Because you got every single circuit court in the country reversing the decision and declaring a power that doesn't exist under the Constitution or in the statutes is the power being exercised and enforced by authorized courts that are authorized under the 16th Amendment. It's given us another civil war. That's how bad this decision is. It's where the division in America has occurred across the lines of class warfare. And this Moore decision puts it all to sleep. It kills it. It's the Supreme Court reaffirming 111 years of consistent, unchanged precedent. A federal income tax is indirect. It's not the non-apportioned direct tax that the federal government has been enforcing, assessing, putting people in jail for, taking their homes, their cars, their bank accounts, their pensions. Every single seizure for 65 years has been constitutional fraud by a conspiracy of treason by sedition within the lower federal courts. Every federal judge in the country should be arrested, put in prison, put on trial for treason, and shot right after the trial. Because they're going to be convicted. The Supreme Court just laid it out. It's indirect. It's never been direct. Every single one of the lower courts are lying to you. And the only thing I don't understand is how is it possible I'm the only person in the country that understands the repercussions of this decision? They lay out clean constitutional law that's been in place for 111 years. And nobody gets it until you show it to them. Then they get it. Now, the court has taken them down. They've given us what I've been saying for 25 years we need, a reaffirmation of the Brushaber decision. We don't need a new decision. We need a reaffirmation by the Supreme Court of what they did. And that's what they've given us. In laying out the constitutional foundations for indirect and direct taxes, where direct taxes must be apportioned without exception, and indirect taxes are only required to be uniform and are allowed to be without apportionment. They lay it all out. Since the Civil War, there hasn't been a direct non-apportioned tax. There hasn't been any direct tax since the Civil War. And when asked by the court to identify a direct tax in the Internal Revenue Code, the Department of Justice said they couldn't do that. Well, that's funny. In every other single court in the country, district and circuit, they argued it's a non-apportioned direct tax under the 16th Amendment. So they managed to find it for all the other judges. But they didn't want to show it to the Supreme Court because they know the court would have said, error, 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 all 9 times. And that would have been the end of the income tax system. So they conveniently omitted the argument they make in every single other court in the country. But for the Supreme Court, they couldn't find one. And when the court said there hasn't been one since the Civil War, they didn't rise up. But Your Honor, what about the income tax? It's a direct tax, a non-apportioned direct tax under authority of the 16th Amendment. You forgot about that? You forgot about that, huh? error, 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 or fraud. Yeah, fraud. Well, I guess I shouldn't be too surprised that the legal community is just brain dead on this matter. I mean, after all, we have a vice president who was Attorney General of California and doesn't know she can't codify Roe, because when they rule in Dobbs that there's no constitutional authority for an opinion from the Supreme Court, it means there can't possibly be any constitutional authority for a law from Congress from either side. The Republicans can't ban it federally or set limits on it federally. And the Democrats can't authorize it to be allowed in all 50 states at the federal level. Any statute Congress writes will be declared unconstitutional, just like the Roe opinion was declared unconstitutional without constitutional foundation to act. This court is taking out all of the unconstitutional holdings that came out of the early 60s in the communist socialist court at the time. They took down Roe v. Wade. They've taken down affirmative action. They've taken down regulatory deference. And in my opinion, this Moore case takes down direct non-apportioned income tax. It's over. Every single lien in the country is fraud. No state court can enforce this. No state court can enforce any federal lien because the lien was based on a claim that you owe a direct non-apportioned tax under the 16th Amendment, and that's not true. It's unconstitutional, and the state courts can't enforce unconstitutional fraud any more than any other court can. The liens in every state court need to be taken down by the state judges. Enforcement needs to be barred until the federal government comes into the court and presents evidence to the state court that the assessment was based on an indirect impost, duty, or excise. And since they didn't argue that in the matter when they issued the lien, they can't argue it now because their frivolous positions document asserts repeatedly, citing from every circuit that I went through earlier, that Bruce Shaber Court declared the income tax is a non-apportioned direct tax under authority of the 16th Amendment, and it's frivolous to argue anything else. Actually, that was the frivolous argument. It's the IRS, the DOJ, the district courts, and the circuit courts of appeals that have been making the frivolous argument for 65 years. 65 years of constitutional fraud. This is a multi-trillion class action suit for everyone in civil court across the last 45 years and every person convicted in criminal court for the last 45 years. Every single action was unlawfully and unconstitutionally conducted by a court that lacked the subject matter jurisdiction to conduct the trial. They had no authority to enforce a claim for a non-apportioned direct tax, which is what the IRS has been assessing, what the DOJ has been arguing, and what the federal lower courts have been enforcing with judgments and verdicts for over 45 years. It's actually an 80-year fraud that dates to the end of World War II. But they only cite circuit court rulings from 1980 forward. But they were enforcing the tax from the late 50s up to the 80s as though it were a direct tax. Just nobody challenged it artfully enough to get a ruling on it. And then the circuit court started handing out $25,000 frivolous fines for pro se litigants making the correct argument. Making the correct argument. It turns out it's not the pro se litigants that are silly or stupid and don't know the law. It's the circuit courts that are corrupt, seditious, fraudulent, lying, Orwellian pigs, enforcing the rule of "we say so." It's got nothing to do with law or constitutional taxation. 100% "we say so" nonsense. And the Supreme Court just kicked the chair out from underneath them, leaving them hanging from the gallows tree. And the strangulation has already started. It's just a matter of time. All the work's been done. All the evidence is there. All the proof is right there. TaxFreedom.com. Head on over and start reading. Article right on the main page. SCOTUS killed the income tax. Here it is. Just head over to TaxFreedom.com, read the article, and download the documents that prove it. I got the frivolous position documents that prove they've argued it's a non-apportioned direct tax under the 16th Amendment, and I got the Moore decision where the opinion clearly recites over and over and over again, citing Bershaber, the original decision, that it is an indirect tax. It was in 1913, and it has been ever since, never changed, no possibility of any intervening change. Courts have been lying to you, America. It's time to terminate this communistic fraud. We need a real tax system that taxes the corporate subject, and sufficiently so to fund the legitimate operations of government, and removes the burden of the tax system from the backs of labor, who were never the intended subjects of the tax. It was a tax on corporate privilege, not labor. It was a tax on commodities, alcohol, tobacco, and firearms. It was a tax on licenses, alcohol, tobacco, and firearms, and interstate transportation of petroleum fuels. It was never a tax on labor conducted by occupation at common law by right. Never. This is all perversion and sedition, communistic sedition, perpetrated by the circuit courts of appeals, the second highest courts in the land, have committed sedition and treason in order to enslave you to the servicing of the $36 trillion in debt owed to the Federal Reserve Bank, which is where all the money raised, taken, withheld, collected, and sent in with Form 1040. That's where it all goes, is to the Federal Reserve Bank, a private corporation. Check the back of the last check you sent. See if it says deposit to the U.S. Treasury or pay to NEFRB. I'll guarantee you it says pay to NEFRB unless alcohol, tobacco, or firearms is involved, or incorporation. So we're suffering under 65 years of communist perversion imposed by judicial treason, effected by judicial legislation, by doing things in order to support the claim that it's a direct non-apportioned tax under the 16th Amendment, like putting a regulation behind Section 1 that says you're liable for the tax when the statute doesn't say that. The statute doesn't say that because it's not a direct tax. It's a tax on taxable income that is withheld by a collector who is then made liable for paying what he's collected. No one is made liable for the money they earned working. That would be direct. It's indirect. The burden is shifted. It's the collector who withholds the tax, who's made liable for turning over to the Treasury what he has collected from other persons. And the tax collector, the true taxpayer, never pays a dime out of his own pocket. He just turns over what he's collected, just like a store does with a sales tax. And everybody thinks they're the taxpayer because the money that paid the tax came out of their pocket. No, 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 I'm sorry, you're not the taxpayer. The tax collector is the taxpayer. The man who collected is the person made liable for the payment of the tax, not the person who worked. It's been a constitutional fraud for 65 years. Get on over to TaxFreedom.com, get educated, wake up, spread the word, share the information. Everybody in the country needs to know this. Everybody needs to know this. taxfreedom.com. This is Thomas Freed on the Liberty Works Radio Network. I'll be back next week. Get to the Thomas Freed YouTube channel. Watch the videos. Thank you. Always fun. You too.